So my first question to you would be, what do you think a key takeaway from this Adani-Hindenburg?
There are about 5 takeaways. The first is that the Supreme Court has upheld the Sebi report on 20 out of 22 instances. It has rejected the demand for an SIT. It is further stated that there is no conflict of interest. Fourthly, the Supreme Court has taken a view that there is a need for inquiry and investigation into the loss suffered by investors. And fifthly, that media reports should not be the basis of newspaper reports. Media reports should not be the basis of PILs necessarily. The court has also expressed its reservation and its views on the OCC RP report as also the report of Hindenburg, and said that they would rightly and go by the report of Sebi, which is the concerned regulator, and it has found Sebi's systems and regulations to be robust. Of course, it is said that they must also look at the recommendations of the separate committee, but the point is that it is always essential to keep upgrading regulations to make sure that there is a robust mechanism both for companies which go on the stock market as also for the investors who invest in these entities.
The Supreme Court has disposed of the case today, but what will happen to the 2 cases which are still under probe, and the Supreme Court has set a deadline of 3 months? What will happen to that?
I think that is something which will be in the public domain, because the Supreme Court has recorded the undertaking of the Solicitor General that the remaining investigation will be done within 3 months, and that undertaking will result in a report which should be in the public domain in due course and within 3 months.
So don't you think that the Supreme Court has curtailed down the freedom of press today by saying that the petition, the PIL should not be based only on the newspaper reports?
This was the issue regarding PILs being based on newspaper reports were dealt with way back in 2005 in Dr. B. Singh's case. So it is nothing new. There was a period when Supreme Court was relying upon newspaper reports. The question is, it is not just newspaper reports. Is it an opinion or is it substantive evidence? Now, there can be a newspaper report quoting from substantive material and evidence, and if the underlying material exists, there would be no occasion not to rely on such underlying strong material. But if it is only an opinion or a viewpoint, then I would also believe that the Supreme Court's decision that you can't go by people's concerns and anxieties alone, you have to go by strong, hard evidence, because an interference in a PIL jurisdiction has consequences.
So what's your take on basically the Supreme Court taking over the investors' interest as a paramount thing? During the hearing also we have seen that. So what do you think that, the Supreme Court has done, adopted a right approach today?
I think whenever a PIL is filed, what are you looking at? Public interest. And therefore the investor's interest is paramount when you come to look at investigations, especially in the context of people who have invested perhaps their life savings or even taken loans to invest in the stock market.